My name is Kimberly Wittenberg-Lurie, and I'm here today representing the appellant, Mr. Victor Lopes. May it please the Court. The statutory rights and consent form never should have gone before the jury. Admissibility of the breath test results was a question of law for the Court to decide. By allowing the statutory rights and consent form into evidence, an impermissible inference was created that the defendant must have known he was guilty since he did not offer any exculpatory medical evidence.
Excuse me, did you include in your brief the part of the statute that says that it's necessary to consent to, that the Commonwealth, that in order to make the results admissible, the results of the test admissible, there has to be a consent to an informed right to a medical exam?
I believe 5A is included in my brief, in the appendix.
Is that part of 5A in your brief? I see 5A in your brief, but I'm talking about 24E1.
24E.
Which it seems to me is the linchpin of the whole case, and I couldn't find it in either brief.
It would seem that's not in my. It would seem
Well,
it's
it
not
wasn't in the
brief.
Commonwealth either that I could find, and it's very distressing because when we're reading these briefs, not to have the key sentence of the whole statute included makes it rather difficult, wouldn't you think?
I apologize, Your Honor.
Okay.
Whether you consider the admission of the statutory rights and consent form a violation of Mr. Lopes' post-arrest silence or an admission of refusal evidence, this error was not harmless beyond a reasonable doubt.
Just going back to that, is it your view that it's not an issue for the jury as to whether or not the defendant consented to the breathalyzer, that that's simply not a matter that the jury may consider?
Under the per se prong, what you need is to show that the defendant was operating the motor vehicle, that he was on a public way, and that the breath test results are .08 or greater. Okay? Nothing in that statutory piece seems to go to the jury needs to be presented with evidence of consent. Where consent is important is the breath test admissible or not? Okay? Lack of consent would throw that out. Now,
Okay, and did you invite an instruction to that the court would tell the jury that the issue of consent is not before them, or did you stipulate to the issue of consent?
Actually, consent was stipulated to. I believe it's on, I want to say, page, that he's not, page 93 of the transcript at the very bottom, when they say, the court and the Commonwealth seem to be saying, well, we need this in to show the whole landscape and the voluntariness of the breath test. And defense counsel asked for that piece, the medical exam piece, to be redacted because he felt like it was a comment on silence.
But did he?
And then he goes on to say, and he's not contesting that. The court said, I will look, I think, as I started to say, it would seem to me they have to find that it's a voluntary decision, meaning the jury. And he says, but he's not contesting that. This all was going on inside.
Right, but there's a difference between not contesting it and stipulating to it and having the jury be told there's a stipulation of all the parties that the defendant consented to the breathalyzer. And I gather there was none here.
No stipulation, but none, as I said, and the defense counsel even went on to say, if we were arguing consent, okay, then it would make sense to bring it in, meaning the statutory form, and I'm not sure I agree with that. But defense counsel seemed to think that at least then it would have some relevance if consent was being disputed.
What relevance if the statute says, the part of the statute that I just quoted says that there has to be that information provided to the defendant before the breathalyzer test can be given? Why isn't it relevant?
Well, it's relevant to the question of law that the judge, that whether that breath test result is admissible. We're not asking the jury to decide if he gave consent. Once the breath test ticket says .08 or greater, we have a public way and we have operation, which we're stipulated to. Really, the way you attack this per se prong, I believe, is you go after the lack of reliance of these tests. You go after the operator errors. You don't
so
go
you're
after
saying it's sort of like a motion to suppress.
Actually,
in other
the
words,
cases,
if you lose the motion to suppress, nobody's talking. You don't revisit the issue at trial. You
right.
just accept that that's that, and you go on.
Absolutely, Your Honor, because the cases cited in the Commonwealth's brief, interestingly, going to this issue of whether it's a question of law or a question of fact, are both motion to suppress hearings, I believe, on appeal. Okay, so what that meant to me was they were trying to get those breath tests thrown out, those results. In our case, we weren't disputing the breath test results. We were just attacking them in terms of the validity of the machines. And so when you bring in this very prejudicial piece that, hey, this defendant had a right to a medical exam, and then the jury sees no evidence presented, what the doctors said, and what are they left to think? They're left to think either he knew he was guilty and no results were given, he didn't even pursue it, or he went to get an independent medical exam and the outcome was bad, and why would we bring it in? Right. So, bringing this piece in, there was no relevance for the jury where it's not being disputed. And
well, even if it were disputed, is it a jury question? I
don't think so. I think at that point you go up on interlocutory appeal to say, hey, there was no consent. This breath test ticket should never even come in.
So it's like, in a way, that the consent to search, it's not a jury question. The voluntariness of the consent to search is not a jury question, but voluntariness of a confession, which is a different question, that is a jury question. But this is not a jury question, you're saying?
Absolutely not. And I think the prejudice that resulted from this error is too great. I don't think you can call it harmless beyond a reasonable doubt because, the whole defense went to the credibility of the defendant.
I know, but this wasn't even mentioned, was it? I mean, there was no argument about this. There was no the police officer wasn't asked a question, I don't recall, maybe you know. Well, did he request such an exam? No question was asked like that?
No, but there was a fight.
He was just advised of all of these rights, and then he agreed to take an exam. That's the beginning and the end of it. No argument about that? No, nothing.
Well, not in front of the jury.
Well, no closing argument. The prosecutor didn't point out...
Well, he was told not to. Interestingly, the court said... Well, no, the court said when he admitted it, in fairness, the court said when he admitted it, hey, we're not going to argue this. And he said, hey, I'll give you a curative instruction if you want it, but I sure wouldn't advise it. So the court knew he was letting something in that we didn't want argued, but yet the jury sees it. But
it wasn't even mentioned by the officer. The officer just said, yes, all the rights were given him. And
absolutely, but...
That's all.
But then it's in front of the jury in the form of the consent form.
Yes, that's my argument, really. You can say it wasn't argued, and you can say no specific questions were asked, but where the juries took a breath test ticket into deliberations, as well as this form that really enumerated their rights, I think it's sort of the elephant in the room.
But what is the constitutional violation? There's no taking of anything from the defendant. It's not like when he refuses the breathalyzer. It's not the same thing.
Well, I think there is. I mean, I sort of analyzed it in the whole testimonial, and was he compelled?
But there's nothing testimonial. That's the thing. It's not testimonial in any way.
I see it, the way I saw it as testimonial was that it was admitted for voluntariness. It was actually admitted to show that he consented to the breath test. And then it was admitted to show the whole landscape, what he was thinking when he consented. So I think it is testimonial in that it's going to his state of mind when he agreed to do the breath test. And I think it is compelled because when you look at it under sort of this framing, it's compelled because he's under arrest. There's some inherent coercion. He's in custody. He's told to sign this form, just as he's told to take a field sobriety test or take a breathalyzer. Defendants to sort of
start... So now you're saying it may not have been voluntary. Is that what you're saying?
The signing of the form, I don't believe, was voluntary. The whether or not you want a medical exam is a choice that becomes very...
I'm confused. So you are contesting the voluntariness of his agreement to take a breathalyzer?
No, that's not being contested. But what I am arguing is that this right to a medical exam was very prejudicial, where he presented no evidence.
But a medical exam can mean so many things. If someone mentioned to me a medical exam, I wouldn't think medical exam to draw blood to test.
Isn't the form say that, though?
I believe the form does say that. It goes into that you have a right to an independent medical exam. I mean, the person's being arrested for an OUI. There's sort of it's not an arrest for,
Yeah, but
robbery.
how do you equate it to a statement or a refusal to make a statement?
Well, I think it's sort of like just silence in the face of a statement. So it's the lack of response elicited, I think creates something.
Do police officers ever recite Miranda warnings in court? I gave him the Miranda warnings, ba-ba.
It's never clear that they did. He said that he went over his rights.
No, not in this case, but in general.
Yes.
Do police officers state you have the right to remain silent, ba-ba, each of the Miranda rights? Well, why, by saying you have the right to remain silent, is that, would the next step of your argument be that that's somehow akin to this right to an independent medical exam, because by remaining silent, the defendant isn't speaking?
Yeah, I mean, that is the argument, and I don't think it ever comes about, though, this argument, if this form doesn't come in. This form created that silence, okay? Once that form comes in...
No, I am asking you,
yes,
police officers testifying in court, it seems to me, many times, I gave the defendant these rights, in another case, not in this case. I gave him these Miranda rights, including the right to remain silent. Are you saying now that would be improper also?
No, I don't think that's improper.
Well, what's the difference between that and this?
Because I think in an OUI, an operating under the influence case, we have something very specific and inculpatory. We have a breath test ticket, okay? And I think when a jury learns...
Well, what if we had a confession and the police officer said, I gave him his rights. Here are the rights I gave him, the right to remain silent. And now we have a confession, which is certainly as inculpatory as a breath test. Are you saying that the police should not be able to say, I gave him the right to remain silent?
I think they have to know that they got the right to remain silent, because otherwise I think it gets thrown out. Because that's a question for a jury to decide, whereas this is a question for the court to decide, the admissibility.
Are you saying that the jury had... yes, you did, but are you saying that the jury has nothing at all to do in deciding whether the test was taken voluntarily?
I am arguing that the jury does not decide whether a breath test was given voluntarily. That is a question for the court to decide. Under the per se prong, the reading I had is it has to be determined the consent was given for the breath test ticket result to be admissible. Okay? And then, per se prong, I mean, the legislature was trying to make it pretty easy to convict defendants on it. You got to prove .08 or greater, operation, and public way. And then your opportunity to attack that per se prong seems to be going after the equipment, going after... Consent is really a question of law here.
Well, let me just sort of go back to a point about the Miranda rights. If a defendant does not give a statement, we don't allow the Commonwealth to introduce evidence that he was given his Miranda rights, including the right to remain silent.
Right.
There's just no evidence.
Right.
And I thought that your argument was along those lines, that where there's no contest, that he got the right, and that the breath test was administered voluntarily. Notification of the right to take to have an independent doctor's examination was in some respects like being advised of your right to remain silent. If it's not an issue in the case, if he didn't have the doctor's exam, if he decided not to take the doctor's exam, if he's not contesting the voluntariness of the exam, you don't introduce those predicate questions.
Absolutely. I mean, the argument I'm doing the argument in a couple of ways. First of all, I don't think it was admissible. Consent was not admissible because it was a question of law. Okay? Now, if you, for some reason, think it should have been admissible and that the jury should have, once you introduce that, okay, and then you provide no exculpatory evidence, meaning the defendant doesn't, there's extreme prejudice there, really, for no need, where consent wasn't being objected to.
But how far do you carry that? I mean, let's assume the judge at the beginning of the trial says, members of the jury, here's how this trial will proceed. The Commonwealth will proceed first. The defense then has the opportunity, if they wish, to offer evidence. They have no burden to offer evidence, but they may if they wish. And then the Commonwealth rests, and the defense rests. Can you argue then, well, that instruction was error because the jury was told that they had the opportunity to do something, they didn't. They can infer from that they had nothing to offer. I mean, do you go so far as to say that type of instruction is error based on this argument?
No, I don't go that far. But what I do think is I think a reasonable juror who knows someone's been arrested for operating under the influence, okay, sees something that someone was given, this arrested person was given a right to an independent medical exam, they think, I can't help but think a reasonable juror would think, hey, an innocent person would go get that exculpatory evidence.
Well, what if their thought was, well, you have to pay for this thing, and this defendant didn't have the resources to pay for it? Or if they thought, I want to get that defendant wants to have a particular doctor do it, and that doctor's not available. Well, I guess what I'm saying is, aren't there other explanations for why a person might not pursue that other than they're guilty?
You know, you and I know that, Your Honor, okay? We know that the case law in 5A is you have to transport yourself, you have to make the arrangements, you have to pay for it yourself, right? I don't think jurors know that, okay? I don't think even the most sophisticated juror knows what 5A really puts a burden on the defendant if in fact they want to get that exculpatory evidence. I think a juror, just a reasonable person, sees someone arrested for an OUI and then no evidence comes in. I think there's a consciousness of guilt there.
Well, if you're right, I'm wondering what the harm is, because didn't the defendant testify that he thought that a police officer told him he had blown a .05?
Right. You know,
So why would you need a medical exam? Even if you had the right to have a medical exam, why would you need one if you thought that the police
Well, in fact,
officer...
he didn't. It's not clear on the record if he pursued one. The issue is more...
No, what's the harm?
The harm is I think that they had two pieces of evidence to decide on this per se prong. One piece of evidence was the breath test ticket, and the other piece, exhibit number 1, is this right to a medical exam. And this right to a medical exam, you know, raises this consciousness of guilt argument, and I think there is harm there. You know, I don't think you can say it's reasonable beyond, or, you know, harmless beyond a reasonable doubt that this defendant was not impacted by the knowledge that the jurors had that he could have pursued this exculpatory evidence.
We'll have to leave it there.
Thank you so much.
Good morning. My name is Suzanne McDonough. I represent the Commonwealth in this case for the Plymouth County District Attorney's Office.
How is this relevant to the trial where consent is not an issue?
Your Honor, to answer that question and to answer Justice Cowan, your question earlier, the Commonwealth did include in its brief Chapter 90, Section 24, Paragraph 1, Subparagraph E, which does provide that the breath test should be admissible and deemed relevant to the determination of whether or not the defendant was under the influence, provided that...
What page?
I'm sorry, Your Honor. It's page 15 of the Commonwealth's brief.
Yeah, I've read that many times, but it leaves out the key part. It's ... for the part that we really need.
That is right, Your Honor. I did cut it short, but it does include that it was made with the consent of the defendant.
But it doesn't include the language that he must be informed of his right to an independent medical exam.
That's right, Your Honor.
Okay.
But
Is it a jury question?
Well, Your Honor, I'd suggest that at trial, all questions of fact go to the jury. They're the ones to decide whether or not they can depend upon the evidence that's presented to them. And in this...
With a motion to suppress, that it's before the jury, whether that was a fair, that the evidence should or shouldn't have been suppressed is a question for the jury?
Well, Your Honor, in this case, there was no motion to suppress prior to trial.
But analogously.
Right. That I understand, Your Honor. That would, if a motion to suppress was dealt with before the trial, it would certainly be out of the purview of the jury. But here, there was no motion to suppress, and thus the consent of the defendant is a central question for the jury to decide, especially here, because the defendant, in his questions of Sergeant Lofstrom from the Brockton Police Department, who conducted the test, and in his closing arguments, and several points in his closing argument, contested the validity of the examination.
But was the jury told here that they must first find consent before they may consider it?
No, Your Honor. I don't believe...
So if they weren't told that, if it was essential for the jury to so conclude, then how does your conviction stand?
Your Honor, they must rely upon the breathalyzer test in order to convict the defendant. And the defendant here questioned the reliability of the test.
That's a different question of whether you consented to taking it. That goes to whether the machine works or whether it's been properly tested, doesn't it?
Well, Your Honor, basically, the judge in several points, when he was considering whether or not to admit the evidence, Judge Janine from the trial court, specifically on page 100, stated, to the extent that there are safeguards and backups available to the defendant, It means that the jury can be safer in relying on the results of that test. So therefore, since the defendant can rely on the results of the tests and was voluntarily doing it, thus so can the jury, I'd suggest. His consent to do it, I'd suggest, is a consideration that the jury should take into account when they're deciding.
Did the judge instruct anything in his instructions to the jury about the issue of consent?
That is not my recollection, no. I don't think that he specifically stated that they must find it was consensual. But in order for...
Did either attorney argue the issue of consent?
While the defense attorney at sidebar...
No, I don't care about sidebar. Did they argue to the jury?
He did not argue to the jury the consent to the test. He did not concede it. He did not stipulate to it either. So it is...
But what is there to concede if it's not an issue in the case?
Well, Your Honor, what he was contesting was the validity of the exam. And I think that the defendant's voluntarily entering into that exam bears on whether it's reliable for the jury. What I'd suggest is that the defendant here is asking this court to make an illogical jump in reasoning. And he's saying that because there is this right to the doctor on the statutory rights and consent form and a lack of evidence presented, that those two things together is refusal evidence. Well, what I'm suggesting to the court is that there was no communication that was compelled by the police. There's no question or put to him by the police that demands a yes or no. There's no statement by the defendant. The police followed the statutory procedure that they must under Section 5A and the public policy that lies behind that procedure in giving the defendant the right that he must have. And then the defendant answered, yes, I will consent to a breathalyzer test.
Did the defendant testify that he testified that he got a .25?
Yes.
The defendant himself testified that.
He did testify at the trial. He did testify, in fact, that he thought he had a .05. The evidence was that he, in fact, had a .25.
Right, well, how does the fact of his refusal, of the defendant's refusal to obtain an independent medical exam impact his guilt if he takes the test and he gets a .25?
Well, Your Honor, there was no evidence of a refusal in this case. The jury had no evidence about what the defendant did in regard to this exam whatsoever. So the jury would have to speculate completely in flying in the face of the judge's instructions in order to reach the conclusion that the defendant suggests he did. He says, because they had this right and because there was no evidence, thus it bears on the wheels turning in his head that he must be guilty. Well, there was no evidence to that effect. He very well could have, because the defendant is in control in this situation. This is a sort of defendant-centered right. He decides whether he goes and gets the tests. He decides whether a doctor comes to the police station and gives him the test. He decides whether it comes to the attention of the police or to the attention of the jury at trial. Because of that, the consciousness of guilt is not the only necessary inference to be made from the facts. The jury very well could have assumed that, or they didn't know, and the judge is instructing them, don't speculate about what might have happened. They don't know if he left this police station, walked down the street, went to a physician, and got an exam, got a .20, and decided to rip up that result and throw it away.
Tell me again what the judge instructed. Don't speculate. Precisely. What was he referring to?
There are two spots in the transcript in which the judge instructed the jury about speculation and what they're to base their verdict on. One was a transcript on page 172. That was on the general instructions. And then on the transcript, page 129, which are both in my brief on page 18. The judge at first told them they are not to engage in guesswork about any unanswered questions or speculate about what the real facts may or may not have been. Then, after a question, he instructed them to decide the case based on the evidence presented in the courtroom, not to speculate, and also stressed that the Commonwealth is responsible for proving the case beyond a reasonable doubt.
So these are general instructions, nothing specific related to don't speculate about this form or don't speculate.
Right, that's right, Your Honor. There was no reference in the case whatsoever to this form or this right.
Would you agree with me that if the prosecutor had asked the police officer after you advised him of these rights, did he in fact request a medical examination? Would that have been improper?
Well, Your Honor, if it may have changed the situation, but that's not the case here. The defendant here, there was no comment or no suggestion made to the jury of what the defendant actually did. Therefore, there was no prejudice suffered by the defendant in this particular case. There was fairly overwhelming evidence of the defendant's intoxication here. There was no discussion or question about this particular right, and therefore it's very highly unlikely that this right, the right to an independent medical examination, entered into the jury's calculus about whether or not to convict the defendant.
Was the booking video of the field sobriety test or a test at the scene, or a test at the station or on the scene? I wasn't clear from what I read in the brief.
The booking video, Your Honor, is a DVD which reflects that there were some field sobriety tests done at the police station.
Oh, so there were field sobriety tests done at the police station?
Yes, Your
and
Honor.
that's on the DVD, which
Yes.
was shown to the jury?
Correct.
And how did the defendant pass or fail them?
Well, Your Honor, I'd suggest that that DVD could be viewed by the jury and they could view whether or not the defendant passed or failed. They had not only the testimony of the police officer on which to base their verdict, but the testimony of the sergeant who administered the breathalyzer result itself, the DVD which they could view themselves.
Have you seen the video?
I have not, Your Honor.
He was not, but he was found not guilty under the impairment?
Well, Your Honor, they did not return a verdict of guilty on the impairment. They did return a verdict on the per se prong and a verdict of guilty on the negligent operation prong.
Could they, shows my ignorance of these, but could they have found both?
Yes, Your Honor. They could have convicted him of both one or the other.
Is it your view that if there had been a stipulation here as to consent, that this form would not come in?
No, Your Honor. I'd suggest that it would still be relevant in this case. What
Relevant to what, though?
the validity of the test being given.
And that's even if the defendant were to stipulate that he voluntarily consented to taking the test?
Yes, Your Honor. I'd suggest that basically the jury has the right to know that the defendant received all the rights that are.
Why? I mean, as Justice Cowan said, if you don't make a statement, the jury doesn't have a right to know that the police gave all the Miranda warnings and the telephone warning and everything else.
Well, Your Honor, here the defendant consented to the breathalyzer test, and he did that. And even if he said, yes, I did consent to it.
He didn't consent to the medical exam.
Right, Your Honor. I think that that is relevant for them to know that he had this right to a doctor as well, and that he decided to take this breathalyzer instead.
So are you saying that there should be a humane practice instruction with regard to a breathalyzer? That we should tell the jury that they may not consider the test unless they find that he consented? Is that what you want us to do?
No, Your Honor. What I'm suggesting to the court is that questions at trial of whether to accept a test as reliable go to the jury. And here, the submission of the right to a doctor, in the context of giving him his breathalyzer rights, bear on the defendant's.
Okay, but isn't that a problem? I mean, the argument there is the breathalyzer is reliable because if it were not reliable, he would have gone. Isn't that exactly what the defense is arguing here? That the argument about reliability is an argument that says it must be reliable because if the defendant thought otherwise, he would have gotten his own test and brought it. I mean, that's exactly their argument.
Well, Your Honor, I would just point to the court to the fact that he did take the breathalyzer test. My suggestion is that the jury should know that he was given all the proper rights, that the police acted properly in this case in giving him all of those rights, and that he decided to take the breathalyzer test knowing that he had these other backups available to him, as Judge Janine referred to them.
But if he could, he may have. I mean, he's refused. You're confusing me. Could the jury know that he refused to take a breathalyzer test and opted instead to take a medical exam?
Well, Your Honor, I think that the case law is pretty clear that they cannot know that he refused a breathalyzer test. If he did in fact take a test with his own doctor, they could know about that. But that's the defendant's prerogative. That's the difference here, is that it's up to the defendant whether or not he exercises the right and whether it's presented to the jury. So it's essentially a different right than the breathalyzer. The defendant isn't being asked by the police to do anything here. whereas a breathalyzer test, he is. There are analogous cases, will you present your shoes to us? Will you give us a hair sample? And if the defendant says no, that cannot go before the jury. But that's not what happened here. Here, it's the defendant has a right to do these things. We're not asking you or telling you what to do. We're not going to assist you in any way. The police have no obligation to do that.
So if the police say to him, you have a right to give us your shoes, you have a right to give us a blood sample, you have a right to give us a saliva sample, they can say that, and even if he doesn't give it to them, is your position.
Well, I guess, but he doesn't really have a right to give them his shoes. I mean, they're not, and in this particular case, they didn't ask him to do any of those things. Therefore, I'm suggesting to the court that the defendant was not prejudiced in any way. The jury doesn't know what he did in regard to this right, and there was no discussion or no highlight about the right. So I suggest that even if there was an error, which I'm not saying that there was, that it was inconsequential to the jury in their finding the defendant guilty.
If I may, the jury may not know what he did, but they know that he didn't present any medical evidence.
Right, Your Honor, but I think
so isn't there an inference there?
If the jury makes that inference, Your Honor, they're going against the judge's instructions. And these particular instructions are really bedrock of our law. The jury has to follow the law that's given by the judge and the evidence that's presented in the courtroom. They can't just suppose, well, maybe he did, maybe he didn't. I'd suggest that is the key here. They can't go beyond what they do actually know. And that's the illogical jump the defendant is asking you to make in this case. If the court doesn't have any other questions, I'll rest on my briefs.
Thank you, counsel.
Thank you, Your Honor.
Thank you.